few more things about selecting guardians. Oftentimes, couples struggle between themselves. One spouse may want his or her side of the family, and the other spouse may want his or her side of the family. You can simply say, whoever's standing last wins. It's rare for people to die together, but it does happen. In those situations, the trust and wills and other documents should specify order of death and how we're to figure that out. We would like to avoid, if at all possible, a legal controversy as to who is to be guardian. So leaving some instruction is really important. Otherwise, your family has no idea, and your family is just guessing as who should be guardian. And that's terrible to put the family through that. That can create rifts and fights and terrible controversies and simply waste an awful lot of the minor's money. If you do choose, for instance, your brother and sister-in-law, think through, whom am I choosing? What happens if my brother divorces? Is it still appropriate for him to be the sole guardian of my child? Or do I need to have always a couple? Or is it really my sister-in-law who's the great mom and my brother just goes along? It should be my sister-in-law that is the guardian and not my brother, particularly if I'm not comfortable that my brother can do a good job without his wife. Do think about the blending of a family. If I ask my brother to be the guardian of my minor children and he's a parent, are my children going to meld well into his family? Might my child's very good friend and my friend next door neighbor do as well or better if they're willing and able to be the guardian of my child? These are the questions you need to ask. Who's going to be best at this? What's it going to look like when we blend perhaps two families? When I name a couple, do I really mean the couple, or do I really mean one of the couple? And if so, we should name that one. Also think about, if I name a couple and one passes or there is a divorce, what should happen? And specify all these things in your documents. Finally, let's talk about assuring that we not worry about the wrong things. Many times a couple will say to me, well, Jill would be a great guardian, but she couldn't possibly afford to take in my children. Well, there's things you can do to help Jill be a great guardian of your kids. First of all, your wealth will be left in a trust to take care of the kids. And that's everything from boots and socks and winter coats, school books to tuition. And in your financial planning, you should think about that with life insurance and other savings if you don't have it. But you say, well, but wouldn't Jill need to take time off? Wouldn't Jill not be able to pursue her career if she was looking after my child? Well, that's a real possibility, and things you can think about are leaving assets for Jill, creating a stipend for Jill. Perhaps your family home can become Jill's home, which would reduce the cost of her living expenses because you're providing for the living expenses for your children in your home, and Jill's kind of going along. You could put provisions in your documents that specify that the trustee can assist with the improvement of guardian's home. Think about these things. Make the separation between who's looking after the emotional well-being of my child and who's looking after the financial well-being of my child. If that is the same person, or if there is a guardian trustee team, but the guardian is giving up an opportunity for promotion, does not have resources to look after themselves if they take on the management of your children, not the financial burden of your children, because your trust will provide for the financial burden, but the management of your children, then you can provide a stipend or you could provide a gift to your guardian so that the guardian is not at a loss for having looked after your children.